Good afternoon, folks. Even though the room looks light, there are, I'm told, 4.5 hours of requested argument time. Needless to say, I don't want to keep you here 4.5 hours. So I ask that you ask for the time you need to convince us of your most important points. We are, I assure you, we are a hot bench, and you do not need to educate us and tell us what your case is about. So go to it. And one matter of housekeeping, when there are 2 minutes left, a white silverish light comes on. Be aware of that. Red light will come on after the 2 minutes are up. If you're continuing your thought, of course, complete your thought. And I would ask you to refrain from argument after the red light. Of course, if anybody on the panel asks you questions, then absolutely, the red light is for you and not for us. So having said that, first case is People versus Bennett Archibald. That's submitted. Serafine versus Molina. 7 and 3 and 7. C. Raphael, submitted. Rowley versus Jerome. 5, 2, and 5. And I want to note that Justice O'Neill-Levy is recused from that case. People versus Andre Jackson. Submitted. Extended CHA versus Maloney. 5, 2, and 5. Folks, I'm sorry, is there anybody else?
Yes, Your Honor. Michael Tiffany on behalf of respondent as well. Is now a good time to move my colleague, my co-counsel, permission.
That's fine. So go ahead. You want to make that application?
Sure. Your Honor, for the purpose of oral argument on this appeal, I request that co-defense counsel John Zemo repeat.
That's granted. Perez-Torres versus Cocoa Point. Submitted. Westco Insurance versus Mount Holly.
Good afternoon. Appellate requests 5 and 2.
Request 4.
5, 2, and 4. People versus Khan. Submitted. Brody versus Board of Managers.
Then 5 is to the appellant. Good afternoon. 7 and 3.
Respondent 5.
6, 2, and 5. Carranza versus Memorial Hospital. And that is submitted as well. So first case up is Serafine versus Molina. Anytime you're ready, counsel.
Good afternoon, Your Honors. Sandra D. Parker for the petitioner appellant. In this case, what we have is a situation where Mr. Serafin was found to have engaged in use of excessive force. He was a former correction officer, and subsequently he was terminated after that finding.
Counsel, you fault the respondent for not calling eyewitnesses, but don't the videos show exactly what went down that day?
We disagree, Your Honor. I think what the videos show is, to a certain extent, what a viewer would perceive to have occurred on that day. There were 2 correction officers who were eyewitnesses, and the reason it's important, Your Honor, is because Mr. Serafin engaged in the striking of the inmate based on his perception as to what was occurring at that
The
time.
videos show that he cold cocked the inmate from behind. He was no threat to anyone at that time. Mr. Hewitt, the inmate, was no threat to anyone. It's evident from the video.
Well, we respectfully disagree in that regard in terms of Mr. Serafin's perception as to what occurred. And for that reason, what we have here is a lay opinion of what transpired during the video. There were no witnesses, and pretty much it's not a situation of weighing credibility. It's really a situation where the hearing officer decided to accept the surmise and conclusion of the investigator who was not on the scene at the time.
No, wait, counsel. Didn't the hearing officer watch the video? I mean, we all watched the video. So, and sure, I can say the sky is purple, but if a video shows what it shows and it's inconsistent with the testimony, then there's nothing, are you saying there's something wrong with evaluating the testimony in light of the video?
No, we're not saying that, Your Honor.
I mean, your client said he thought the guy was going to kick him. I was watching the inmates who was shackled behind his back, feet. I didn't see any in the entire video, any indication that he was doing anything other than walking. So I guess my question is, why can't the hearing officer look at that video, hear your client's testimony, and make a credibility determination? Not based on what the investigator says, but her own view of it.
Well, because, Your Honor, what we have here is a situation where you have a correction officer responding to an on-the-scene incident. And
Unfortunate. It was a terrible incident, no doubt.
And
How much time passed between what occurred with the food being thrown and maybe noxious substances and the incident that we all watched on the video?
I think maybe 10 or 15 minutes at the most. That's what transpired. And in terms of other considerations to keep in mind, Mr. Serafin would not have been in the area had the correct probe team responded. Mr. Serafin also would not have been in the area had the cell door for the inmate who was in and out during the incident trying to interject himself into the occurrence. Mr. Serafin also did not receive any type of training for this particular unit. This particular unit was known for housing inmates who pose safety threats to staff and to other inmates.
That would go to the penalty, wouldn't it?
I'm sorry?
That observation would go to the penalty, wouldn't it?
Well, I think it certainly goes to the.
Let me ask you this. This is an Article 78 proceeding. There's been a finding against you by the commissioner. What's the standard of review?
Substantial evidence.
And how do you see us upsetting that finding based upon a substantial evidence standard?
Well, based on the arguments that I made in my brief concerning relying on lay testimony, I understand Your Honors disagree with regard to that aspect of it, and no eyewitnesses.
Can you win
being
a substantial evidence reversal based when you have the video evidence that's present in this case?
I'm sorry, I didn't.
When you have the video evidence, can you win a can you get a reversal on a substantial evidence standard in light of the video that's present in this case?
Well, I think so, Your Honor, because Mr. Serafin's conduct was based on his on-the-scene perception as to what transpired. I think an after-the-fact review of the video, someone sitting back and saying, well, you know what, I don't think that's what happened, but he was there at the time, on the scene, and that's what he perceived. We're not arguing, for example, well, maybe the court should accept his perception, but that's what he perceived at the time. And after the fact review may point to a different conclusion, but we believe that the hearing officer should have taken that into account, and she did not. With regard to the other evidence, she imposed the severe penalty of termination when he had an unblemished record. She relied on what was referred to of progressive disciplinary standards, and that was not even in the record itself in terms of finding that he provided a misleading report. He supposedly violated a directive that's not even before the court at this time because it was not part of the evidence. So I think that in terms of the penalty, certainly there were considerations that should have been taken into account, which were not, and we outlined them in our brief. And also, with regard to the hearing officer believing she was mandated to terminate him, she relied on a disciplinary procedure or disciplinary guideline that's not before the court. Thank you, Your Honor.
Thank you, counsel.
Good afternoon, Your Honors. May it please the Court, Diana Lawless on behalf of the Department of Correction. Substantial evidence here supports the misconduct finding. The evidence in this case, especially the video footage depicting the event, which was in the hearing, establishes that the correction officer retaliating after an inmate threw his food tray at him and made threats and insults, and the food tray incident, Your Honor, I believe was 7 minutes.
What should we make of the argument that, in effect, he wasn't really trained for what he was doing on that date, and should there be some allowance for his admittedly emotional response to the scene?
Well, Your Honor, I will point to, first of all, his testimony that it was an emotional response, which he said starting in his use of force report. He said it was an emotional response to the inmate's boasting, and in particular, taking what he said that the inmate assumed, or the inmate said to him something that led him to believe that he had thrown feces into the food that he had thrown prior. The problem with that is that that all corrections officers are charged with following the use of force directive. The use of force directive prohibits the use of a head strike against any inmate. Any force in response to an inmate's insults, threats, or profanity. He said it was insults, threats, and profanity. That's what his reasoning was. That was prohibited force. And any force against an inmate in restraints, unless the inmate tries to resist or assault staff.
But you heard your adversary say that the hearing officer, and I guess we should take into account what the petitioner believed at the time, why he was responding in the way he responded.
Well,
Is that a relevant factor to consider?
It was. I think it is relevant because it's up to insofar as the hearing officer here, the ALJ, is the fact finder, right? So the ALJ was the one who's heard the witnesses, saw the witnesses. I'll also point out that the ALJ actually was walked through the video twice, once with the investigator from the Department of Corrections and once with the petitioner. And the petitioner pointed out to the exact frame where he believed that this person had lifted up his leg. And just like the hearing, just like the DOC investigator, the hearing officer just didn't see it. And it's well established, the precedent of this court, that basically credibility findings, the weight of the evidence, is unreviewable in a substantial evidence proceeding.
So, counsel, can I draw you to the penalty,
Sure.
which is first time discipline termination with a corrections officer who has never been trained to deal with juveniles who are troubled, who asked for a much bigger responding team and didn't get it. And where does first-time discipline firing him fall into this?
Well, Your Honor, I think it. I think it is. First of all, the question is proportionality and to the unjustified use of force, and also the misleading use of force report, which is also what the hearing officer found. I think.
Well, you know, it could be that he really perceived it, even though watching the video, it wasn't true. Sometimes people perceive threats that aren't there. I mean, I don't know that in and of itself is a lie. If he perceived it, he perceived it. It may not have been objectively reasonable, but I'm not sure that favors you in terms of the discipline.
Sure. So, Your Honor, I guess if we're talking about penalty only, I'm assuming that the charges were proven, which is what the ALJ found. But I think that, as Justice Moulton referred to, that the video is very clear, right? It's clear that he came up from behind him, took several steps, wound up and punched him in the head, and he knew or should have known, even if he believed in that scenario, that this person was going to do something. Right.
Yes, we've all seen the video.
Yes,
I'm like,
so that's-
again, is that a proportion, is firing him the proportionate response?
Yes, we believe so because, first of all, that is a determination that, as Your Honors know, a penalty is only an abuse of discretion when the impact is so severe that it's disproportionate to the misconduct or the harm, and that a court can't vacate it just when reasonable minds might disagree. And this is something the Court of Appeals has repeated over and over again in review of these cases.
Is there any guideline at corrections which says the inappropriate use of force in the head area, in the facial area, mandates dismissal?
Nothing mandates dismissal, Your Honor. So there is first of all, the use of force guideline that says that a head strike is prohibited. Correctional officers know or should know that they cannot use a head strike ever, which is what happened here. The disciplinary guidelines, which my adversary refers to not being in the record, that is true in that they were not entered as an exhibit, though marked, but everybody knew what was going on, that these are disciplinary guidelines, that the Department of Correction, which, as Your Honors can take judicial notice, has been the subject of litigation and the subject of very serious proceedings going on there. The disciplinary guidelines were adopted as part of the existing class action, the existing consent decree. Those guidelines do not require, termination where there's a hit in a manner that poses a risk of serious injury and that's punitive, retaliatory, or designed to inflict pain and constitutes a needless risk of serious injury. And this conduct, the hearing officer decided, after looking at it and seeing that it was a head strike, and seeing that, and even the petitioner admits that he engaged in this behavior in retaliation for the words that were being used against him, that fell within the guidelines, and there was no reason to differentiate from that penalty. It was a very serious offense, and it's one that the Department of Correction takes seriously in terms of maintaining.
Is there a precedent for discharge under these circumstances on prior cases, I wonder? Have other correction officers lost their jobs for an unprovoked blow to the head based on an emotional or response or something like that?
Unfortunately, I don't have statistical evidence about that. I don't have statistical evidence about what the Department of Correction has or has not done, but I have pointed into my brief into similar cases, not only of correction officers or other different uniformed officers or other municipal employees who have engaged in similar behavior. And even without a disciplinary guideline such as this, that has been the result.
Does it matter that the inmate was not injured?
No, it doesn't matter at all, because I think what the guidelines say, at least in terms of the force, right? It's the place where you hit, and it's the risk of injury, right? You can't hit in the head, you can't hit in the spinal column, you can't hit in the most sensitive areas of the body, and that's the reason why. And it does not matter that he did not have resulting injury. So we don't think anything here meets the high bar of shocking the judicial conscience, and we ask that this court confirm the decision of the Department of Correction.
Thank you, Counsel.
Thank you.
3 minutes, Counsel.
I only like to add, Your Honor, for consideration is the fact that Mr. Serafin has an unblemished record. He showed up to work on the day that his uncle died. His uncle had raised him as a child. He was sent to the TRU unit with no training, and the DOC requires training to be sent to that unit.
Are there cases that support your position that under these circumstances, corrections officers or other uniformed officers have received less harsh discipline for similar acts?
Yes, Your Honor. I think we believe we cite at least one case in our brief, and the circumstances that the court took into consideration to reject that severe penalty of termination is the unblemished record of the correction officer, the surrounding circumstances surrounding the incident, including the injury that was inflicted or not inflicted on the inmate, and the remorsefulness of the correction officer. And we ask, Your Honor, that
When you say remorse, when was the officer remorseful in this circumstances? Clearly, when the report was prepared, he was saying different things, right?
I'm sorry, I didn't hear.
When was there remorse? When did your client express remorse?
During the hearing, and the hearing officer acknowledged that he was remorseful. He was sorry
How
about
about
it.
after the incident?
Well,
Because there's some time passed between the incident and the hearing, correct?
we think the reports that the incident report that he produced indicate that. He took responsibility for what occurred. In addition
Yet
to,
there was a finding that it was maybe false or misleading, is what he said in that. So, I'm not sure that's in your favor.
and that finding, Your Honor, was based on missing tape interview of the petitioner.
Wasn't that finding just based, as we've sort of discussed here, on a credibility determination of the hearing officer viewing the video and then coming to a decision?
No, Your Honor, I think it was more than that. I think if you look at the transcript of the hearing, she points to the investigator testifying as to what she recalled Mr. Seraphin saying during the interview, which led him to strike the inmate. In other words, he tried to indicate to her what he felt was transpiring and why he struck the inmate. That part of the interview tape was either deleted or lost. And instead, what was presented to the hearing officer was the after-the-fact recollection of the investigator. And I believe if you review the transcript, you will see that the hearing officer relied on that aspect of the testimony to conclude that he lied, supposedly lied on the incident report. He tried to explain during the hearing what he told the investigator, and the hearing officer accepted the after-the-fact recollection, and again, the tape was gone. In addition to that, one other missing piece of evidence was the entry in the logbook. That was lost. The entry in the logbook was a contemporaneous entry, and I think it would have answered Your Honor's question, but somehow DOC lost that. Thank you, Your
Thank you,
Honor.
counsel. Thank you both. Extended CHA versus Maloney?
No, wait.
We got Rowley.
Rowley. Rowley.
Rowley's coming in.
Oh, Rowley, excuse me. Counsel?
Good afternoon. May it please the court. Two fundamental bedrock principles govern the outcome here. First, a terminated contract provision cannot be breached. And second, absent a breach, a contract provision cannot be the subject of...
Can we stop? I'm sorry. I screwed this up. I called the wrong case, and my colleague is outside on a, so I'd
She's
keep her...
not recused on the case.
Yeah,
in this
exactly.
case.
So I
So
don't want to
can
hear
you-
argument. The case I should have called was Rowley, so excuse me.
Rowley is our case now.
Sorry about that. You'll be back.
I was wondering why you were coming up. I'm sorry.
That was my mistake, folks. Okay, we got Rowley?
Yes.
Good. Go ahead.
May it please the court. I represent the defendant appellant Jerome JSD Holdings. We're seeking a reversal of the summary judgment motion denial. Mr. Rowley worked for A&A Moving Company, a non-party in this case, and he alleges he slipped and fell on the stairs while working for A&A.
Counsel, one thing you're arguing, I gather, is that you didn't have notice that they were going to say that this is a recurring condition. Is that correct?
That's correct, Your Honor.
But in the BP, the first bill of particulars, record 47, it says one of the things that the defendant allegedly did not do was fail to repair the subject leak. Doesn't that give you enough of a heads up?
There was nothing about the ceiling, and no, they actually supplemented the bill of particulars around the time they
I
filed.
know, I'm reading from the one from 2019. That's what it says, failure to repair the subject leak. A leak sounds like something that recurs.
Okay, but even if that allegation is considered, the issue here is because the only evidence submitted by the plaintiff is the affidavit of Mr.
Okay, but it's your motion for summary judgment. So how did you, in this case, establish a prima facie with respect to constructive notice?
With respect to constructive notice and
Go ahead.
with respect to constructive notice and recurring condition, the prima facie evidence is the affidavits of Ms. Marmoleos on behalf of A&A Moving, the non-party who operated the facility, who was in charge of inspecting the property as well as repairs and maintenance of the entire property. And it's not only her affidavit, it's her testimony, where she specifically testified that she looked for water damage or leaks or wetness on the
Yeah, but
stairs
in a
before the
premises,
accident.
Counsel, I'm sorry to interrupt you, but in a premises condition case like this one, doesn't she have to do more than that? She has to say, this is my routine, and I followed it on the day in question. And I don't think she did the second part of that. She just talks about what she would do on a habitual basis, but she doesn't talk about the period around the time of the accident. And isn't that necessary, that she says, I made my regular inspection on that day and I saw no water on the steps, or something along those lines?
She did, Your Honor. In her affidavit, in conjunction with her deposition testimony, she did in fact.
But you've got one witness, one employee saying, no, never saw it, and then you have another employee saying, sure, every time it rained, there was water.
And Mr.
And then you have two experts, one who says, no way that this could have been a recurring condition, and one who's saying, of course it was a recurring condition.
Mr. Austin's
Right?
affidavit should not have been considered in the first instance.
Okay,
I set
why not?
forth my reasons because the witness was, the Judge Rodriguez precluded his testimony by order in the lower court.
No, he precluded a post-note subpoena, right?
She precluded,
Oh, I'm sorry, yes.
precluded his testimony.
Post-note subpoena, that's a completely different thing that's saying,
But it's
right?
also late. It was also late. There was a late notice of the notice witness, Mr.
But
Austin.
even putting aside the affidavit,
But it was pre-note of issue, correct?
It was at the same time.
Okay, and then, so you get the note of issue, and here's a fact witness that I know is going to testify as to what the premises appeared like. So then, what are you supposed to do? You're supposed to make a motion to vacate the note of issue because you didn't have an opportunity to depose or talk to that witness, right? Did you do that?
Defendants had 60
I'm
days.
asking you,
Yes.
because I looked, because you raised this, right?
Yes.
Serves the witness notification, serves the note of issue. You have a remedy there, which is to move to vacate the note of issue. Did you do that?
We chose to file the summary judgment motion because
Okay, so then you made a choice, and now you can't be complaining that.
it's well settled that plaintiff is precluded from offering an affidavit of a notice witness who was not timely disclosed.
The witness was timely disclosed on the same day as the note of issue. So then if you want more information, then your remedy is to move to vacate, which you didn't do.
It was in direct derogation of Justice Rodriguez's order.
Again, that was post-note of issue.
Besides these notice issues, you also say you belong out of the case because you're an out-of-possession landlord, right?
Yes, Your Honor.
How did you establish that?
There was an oral agreement between A&A and,
What are the terms of that agreement? How much rent? What are the various conditions? Is there a right of reentry? Who's responsible for?
there was no right of reentry.
But based on what? Based on what,
It was based on the affidavit.
based on a self-serving affidavit of your client?
It's not self-serving because there was no contradictory testimony, Your Honor.
But it's basically him saying, I had an agreement with myself, you know, and so how?
Exactly.
How are you going to get around that if you're the plaintiff? I mean,
It's not an agreement between yourself. They're separate. legal
Did you
entities.
say what the
A&A
monthly,
and
did you say
Jerome-
what the monthly rent was?
I'm sorry?
Did you say what the monthly rent was?
No.
What's the term?
Lack of specificity triggers a month-to-month tenancy of this property. And there was the testimony established a complete relinquishment of control from Jerome to A&A. A&A operated the entire facility and was responsible for all maintenance. But even if we consider the affidavit of Mr. Rowley, Mr. Austin, that affidavit, the content of it is speculative and not based on personal knowledge, does not raise a question of fact.
But even if you don't consider it, it's just the competing experts take completely diametrically contrary positions as to whether or not there was a recurring condition, and that's not something we can address.
The plaintiff's expert relies wholly on the affidavit of Mr. Austin, which in and of itself was speculative to begin with. So his opinion lacks any probative force whatsoever. It was based on his visual inspection of the ceiling 10 months after the accident, so he cannot possibly know the condition of the ceiling as it existed at the time of the accident. Mr. Austin, in his affidavit, stated that he wasn't there at the time of the accident, so he has no personal knowledge. He could not have known the exact area of the stairs where Mr. Rowley fell.
Wait, was your expert there on the day of the accident? Was your expert there on the date of the accident? No. When did your expert examine the ceiling?
Oh, at the same time as Mr.
Okay, so I guess my thought is there.
You don't even have to rely on Mr. My engineer to meet our prima facie burden. That's our position on this.
Okay, we're talking about an issue of fact, though. If one witness says nothing, Raina, I think her name is,
Yes.
says no, never any dripping, and another employee says, sure, yes, every time it rains it drips, and the plaintiff says that he slipped on water that was coming from the ceiling, why is that not?
Mr. Rowley's
Oh, he didn't know where, though. Okay, he slipped on water, right?
Mr. Rowley's testimony, he conceded he was unable to see water actually dripping from the ceiling that day. And he said he may have heard sounds after the accident, but nothing prior to the accident. This is akin to the Berger case, Your Honor. Mr. Rowley went down the stairs that morning before the accident, every 60 seconds, 10 times, up and down, did not see any water dripping from the ceiling, did not see any wetness, did not have any issues prior to the accident.
1 second, what about Christina? Immediately after the accident, Christina approaches the scene and saw water dripping from the ceiling onto the stairs. What about that fact testimony?
Christina never testified.
What about that? Let's look at record 195. Christina looks and sees water dripping from the stairs. And then plaintiff says he looks up and sees water dripping from the ceiling. There is testimony in the record.
That's not from, Christina never testified.
Okay, the plaintiff says he looked up after the accident and saw water dripping down from the ceiling.
He also stated he was unable to see water actually dripping from the ceiling, Your Honor. And furthermore, this is after the incident. There's no recurring, does not raise a question of fact as to a recurring condition, Your Honor.
Thank you, counsel. You'll have more opportunity on rebuttal.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. I just want to point out something with regard to lack of constructive notice. If you look at 444 of the record, that is Raina I don't know how to say this, Marmologis, I'll call her Raina. Her affidavit, here's what's interesting about her affidavit. In her deposition testimony, she says, I inspect the stairs every morning. The porters inspect the stairs every evening. Look at her affidavit, 444, paragraph 5. She says, the last time I inspected the stairs was 4:30 in the afternoon. So what happened the following morning, the morning of the accident? Not only do we not know what happened the night before, which is 15 hours earlier, she doesn't say what it looked like, how she inspected it, but this actually is contradictory to when she says she normally inspects the stairs. What happened that morning? And also, that's different than when the porters are supposed to clean and mop and do. We have nothing from what it looked like the last time the porters cleaned and mopped and did anything with respect to the stairs. With respect to plaintiff's testimony, he most certainly did. At 172 and then 195 to 200, he says that he looked up, saw water dripping from the ceiling. Christina came to the site and saw that the water was dripping on the stairs from above me. And also, it's also really interesting, or dispositive to a denial of summary judgment, is that Raina admits that while she inspects the stairs, she never looks at the roof. This is coming from the roof. It's coming from a shaft. That's what our allegation is. It's coming from a shaft on the roof, and she never inspects the roof. She inspects the stairs and the walls. The affidavit of plaintiff's expert is startling, all right? He takes 80 photographs. He doesn't do nothing. It's not speculative. He takes 80 photographs. And
How do you respond to the argument that was 10 months after the incident, and it's really not probative of what occurred at or about the time of the incident?
Well, certainly it's not probative of that, but what it is probative of is the fact that the condition existed for a significant amount of time within which the defendant should have and could have noticed it, because what he did testify to is that there was rust.
So you said there were visible indicators of leaks, I think is what he said.
Correct.
But does he say visible indicators of leaks that were there for many, many, many months?
Correct. He says it was yes, it was there. He said it was there for a period of years prior to 957 of the record. The recurring leaking condition that occurred over a period of years prior to his inspection, that this was a significant structural defect, and that there are visible indications of a recurrent leaking condition that's readily apparent to anyone conducting a basic visual inspection. And what's interesting about that is the defendant touts, I inspect this every day. Not only every day, twice a day. So had they done a modicum of an inspection, they should have, could have, and would have seen the stains that are visible and very obvious in the 80 photographs that the plaintiff's expert took on the very same day that the defendant's expert was there. So,
Well, I mean, okay, that's, yeah, I mean, obviously your position is there's an issue of fact. There's another expert that says that this has there doesn't indicate that this is water. And there are witnesses that say, one witness, Mr. Torres, said no water. So it's not quite, as everyone agrees on whether there's a water condition there. I just want to raise one issue for you about your supplemental BPs.
Sure.
Right? The plaintiff is saying, the defendant is saying, I wasn't on notice that you were going to allege recurring condition until your last BP. And how do you respond to that?
well, my response is that our original BP on 46 of the record provides, I mean, again, a bill of particulars needs to particularize the complaint, but it doesn't have to set forth an exact theory, and I think it gives rise to enough that there was a leak that was left unaddressed, and that
So then why serve a supplemental BP that specifically says recurring condition?
I can't answer that. Maybe they wanted to dot their I's, cross their T's, but I would also point out that the deposition that the witnesses were deposed on this recurring condition. I mean, this was part of the depositions, and also the defendants in their motion addresses recurrent conditions. So it's not like it came out of nowhere. given the photographs and given the inspection, even though it happened 10 months later, you can see that this didn't happen overnight. I think that's no surprise. And I think that the pleadings were sufficient in and of itself. This is a motion for summary judgment with defendant's burden to eliminate any issue of fact that they had no notice. And I think the record speaks to it for itself.
Thank you, counsel.
Thank you very much.
With all due respect, Your Honor, this is not a case where we have one worker saying there was water, another worker saying there wasn't any water. Because Mr. Austin's affidavit is the only evidence submitted by the plaintiff to raise a question of fact. Mr. Austin and Mr. Yarmus's affidavit, the expert engineer, relies on Mr. Austin's speculative
But Yarmus made his own investigation. He made a determination or gave an opinion that there was water permeating the building's interior on a reoccurring basis, and there were visible indicators of leaks which were there for a long period of time. Isn't that sufficient to raise it?
That's our position, because it was based on a visual inspection occurred 10 months after the accident.
Yeah, but we're talking about a reoccurring condition and rust and those kinds of items, which
That's speculation.
speculation.
Yes, as speculation, yes, Your Honor. And also, Mr. Austin never indicates in his affidavit whether what he purportedly saw between 2012 and 2021, when he worked for A&A, was whether this alleged recurrent condition occurred before or after the accident. That also renders his affidavit speculative.
Thank you, counsel.
Thank you.
Thank you both. Okay. Extended CHHA versus Mahoney. Counsel?
May it please the court, two fundamental bedrock principles govern the outcome here. A terminated contract provision cannot be breached.
So what changed between your first motion to dismiss, which resulted in an earlier opinion by this court, and your motion for summary judgment here? What new circumstances do you point to which should result in a decision different than is reflected in our prior decision?
Two things changed, Your Honor, and there's two reasons why summary judgment is required here. First, as to the termination of the agreement, it was possible on remand that the buyer could have submitted some facts, some showings of waiver or forfeiture that could have required a different result than the granting of summary judgment. We challenged them to make such a showing by filing our summary judgment motion, and they failed to do so.
But we had already determined that there is an issue of fact.
This court did not determine the effect.
Yes, we did. We determined that there, I sat on that panel, counsel.
I know you did, Your Honor.
And I'm really shocked that you made this motion, I have to say. We determined that there was an issue of fact as to whether or not there was a waiver of the determination to end the negotiations. I mean, Judge Oink spent pages and pages talking about it.
Absolutely, Your
All
Honor.
right, so please don't tell us that there wasn't. We found an issue of fact. Not a single thing has changed since then. What's your other argument?
The issue of fact, if I could, is that the termination the issue of fact concerned the failure to adjourn the outside date for the closing. And I agree that the court found issues of fact concerning that. Those events occurred on March 26 to March 29, 2021. But the prior panel ruled, Your Honor, that there was a valid and effective termination of the agreement.
A termination, which then the facts of how the parties conducted themselves led to an issue of fact as to whether that termination was rescinded or withdrawn. That's what we found, and you haven't submitted anything else that would change that dynamic.
I understand your.
Okay, so then again, what's your other argument? Because that one, there's nothing else to it.
Your Honor, if I may just make one more
Sure, but
regarding that, and I don't want to waste the court's time, but there cannot be a question of fact regarding the right to stand firmly on strict compliance with the condition precedent, which was wiring the money for the rescission of the termination on March 22nd. I'll say no more on that point, Your Honor. The next point is that summary judgment is required for a second independent reason. The Delaware Supreme Court decision in Yatra.
Did you raise that on your first motion, that case? Did you put it in your briefs, an argument in your first case, in the first case?
We did, but the court
Yes, you did, and we considered it in that case. So this is nothing new or different. That case was raised by you the first time around, and it didn't carry the day then. So why do you think the second time around it's going to carry the day when it didn't then?
It should carry the day, Your
Well,
Honor.
in essence, what you're saying is you're moving to re-argue the prior decision. I mean, that's what it sounds like to me.
I understand that it sounds like, let me tell you why that is not the case. This court and the trial court did not find Yatra controlling based on a false argument made by the buyer. That
Why
argument
don't you look
was,
at the two provisions, section 8.2 in Yatra and 12.2 here, and they're not the same provisions. I will grant you that the idea of there being specific performance after the agreement, and I was not in the prior panel, I'll grant you that there's something which seems counterintuitive to it. But yes, that's what you agree to in the contract, that there could be specific performance after the termination. And your brief acknowledges, your reply brief concedes that there can be specific performance after termination. You just say it shouldn't apply here.
right, we've never disputed that there can be specific performance post-termination. It just has to be, there has to be a breach that is specifically remedied. And the breach can only be a provision that survived termination. Only two obligations survive termination. One, non-disparagement, and two, confidentiality. The obligation to convey the company set forth in section 1.1 is not in the list of surviving provisions.
Yeah, but basically, section 12.2C of the agreement says that all obligations arising under Article 14 survive termination.
Right, and that preserves the remedy of specific performance. But it is basic Delaware law. A remedy requires a breach for it to be invoked. And the obligation to convey the company, read that list, Your Honor, section 1.1 is not in the list. When that provision was terminated, the obligation to convey the company
Again,
died.
we go back to the fact that that there is a question of fact as to whether your termination was effective or not. It may be that it wasn't, and that is what the trial court has
Wrong,
to do.
Your Honor, respectfully.
Okay,
The
fine.
court- This court wrote that the prior termination was valid and effective, that the ability to wire
Except
wasn't-
afterwards, counsel, there was behavior by both sides which led to an issue of fact as to whether or not the termination was rescinded or recalled, if you recall our decision.
Bad faith after the fact of termination cannot revive a dead contract. We are free to act as we desire once the contract is terminated. Good faith went to the adjournment.
Counsel, again, the remedy was to appeal the prior decision rather than make another motion for summary judgment, get that obviously denied, and you come back here essentially asking us to reverse what we did in the prior case, and we cannot do that.
This court never addressed the effect, and I invite you to look at the decision, the effect of the prior termination. One. Two, it ruled that Yatra did not control based on a lie. It was stated that the purchase agreements in Yatra and our situation are different because
Isn't the
Yatra does-
prior decision law of the case?
No, because
Because it's
the
wrong?
court did not have a complete record, and it never passed on Yatra. It did not have the Yatra purchase agreement before it. And that Yatra purchase agreement is identical to the purchase agreement here. The court was led to believe that the Yatra purchase agreement does not have a provision that provides for survival of specific
So this is a motion to
performance,
renew?
But it does.
So this is a motion to renew based on new evidence?
Well,
I'm unclear, when you say we didn't have it, so you argued Yatra, right?
yes.
And we look at the facts of Yatra the last time. What is it that you think we didn't have last time that we have this time?
The Yatra agreement, because the sole defense to the Yatra agreement was the allegation by buyer that, unlike our agreement, it did not preserve the remedy of specific performance. The record wasn't complete, so we tried to submit the agreement to this panel because we found it online, but it was not accepted. So when we were remanded, we did submit the agreement. We said, look, Your Honor, they're exactly the same. And the trial court quoted the false argument. Please look at these sections in our brief because it is demonstrably true that the agreements are identical, provably true. And therefore, Yatra controls. It is an election of remedies, and specific performance ceases to be available even if it was preserved by the agreement. That is the law of the Delaware Supreme Court, and it is foursquare on point here.
Counsel, how do you get around the fact that there was already a determination that there was bad faith that may have caused the frustration of closing?
Sure.
How do you get around that there were issues of fact that say the closing didn't happen because there might be bad faith at play?
That's addressed directly by the court's prior decision at page 15. This court stated, regardless of the fulfillment of other closing details, the adjournment, the delivery of the IT server, buyer merely had to wire transfer the purchase price to rescind the termination. The court held that because the condition precedent was not met, the termination was revived retroactive to March 22nd, 7 days before the closing. What happened after that termination cannot undo the termination. The contract is over, dead and dusted, done. The parties can engage in new negotiations. That may create duties. There could be defamation. But
Okay,
that
that is just not the law, one. And two, if you think it's the law, I disagree with you. So it is not that you can serve a notice of termination and by your conduct show that you don't intend to terminate. That's absolutely what can happen and what we think happened here.
No, that's not what the court said. It is true that we could have served the notice of termination.
Let me interrupt you for 1 second and tell me that it's a little disconcerting for you to tell me what I ruled. That's a little disconcerting, right?
I don't intend to do that.
Okay.
I just want to remind the court, if I may, because we've known Your Honor for a long time.
Yes, I'm telling you,
and
go to trial and prove that the termination was that the actions outside after the termination didn't vitiate it. That's all you have to do.
But I understand, Your Honor, but this case should have been stillborn, and it is not the law.
I do not like that term, so I would
I apologize.
respectfully.
Should not have proceeded.
But your arguments are essentially attacking our prior order, and I think procedurally, even if you're correct, you're not able to do that at this point because it is law of the case, what we found in the prior decision.
Well, that is not the case, Your Honor, for a couple of reasons. One, Yatra was not addressed by the court. In its
Sir, I'm
written
sorry.
opinion.
I'm sorry. I've let you go over the light. You're repeating yourself now. We've heard that, and I will let you give you more time on rebuttal. Counsel.
May it please the court, John Zuma on behalf of.
Why don't we pick up with his last point about Yatra, and of course you set forth in your brief the comparison of the two provisions side by side. why isn't JATRA controlling here?
Well, I can explain that. And one, I just want to address the first point that something was kind of hidden from the court in the first go-around. This case is JATRA. I'm holding it right here. This was briefed, and all of the relevant provisions.
Oh, I agree. I mean, it was put up
recited in the
before us the
provision,
last time. You don't have to argue that. I know it was put up. I read the case several times.
To get to the question of what's different, the two agreements are different, and the operative language, if you have to go to the end of my outline here, is in section 8.2, the termination provision of the JATRA agreement, states that nothing shall affect the right to specific performance prior to the valid termination of this agreement. There is no such limiting language in section 12.2 of the purchase agreement in this case, and that's what this court noted the first time around. But there's another provision which we really didn't get into in the briefing the first time around, which the JATRA court did, and which is also different than this case. And that would be the specific performance provision. And in section 9.9C of the JATRA agreement, it states that a party may either terminate or pursue other remedies. We look at section 14.17 of our purchase agreement. The rights and remedies are cumulative and only limited by 12.2A, which is a section that says that the seller cannot seek specific performance, but can only seek the deposit. So those are the differences, and they've been set forth. I believe this is the 5th time this has been breached, starting with a motion to stay the trial court's order pending appeal, and on and on. So I don't think I need to beat that.
Was there any discovery?
14.17 provision is a little bit of an odd provision, that you have this carve-out that specific performance becomes a possible remedy because the danger of irreparable harm, but nevertheless, that is what the contract says.
Right, and it's actually not as unusual as you think it would be, right? Because there is some Delaware case law which talks about the fact that oftentimes specific performance becomes an issue after the contract. In fact, maybe most often after the contract is terminated for one reason or another. Maybe some party has their material breach, it's terminated, right? A party improperly terminates, et cetera. So yes, I mean, it may be unusual, but that is how the contract reads, and Delaware law says that's good. The other thing I want to address very quickly, because I don't have a lot of time, was this argument which is pinned to this court's prior decision, which is interesting.
Let me just ask you, so there was a termination notice sent, and then there was conduct after the termination notice, which led us to find an issue of fact as to whether or not the termination notice was withdrawn, whether the parties were continuing to go forward as if the closing was going to take place, correct?
Correct. And I've got two responses to that argument because it's really two-pronged. One is that the facts as recited by seller are just wrong, and I think, I'm not asking the court to reconsider anything from the prior opinion, but I think one thing that didn't get picked up on was that after the termination notice and the rescission was a third amendment to the purchase agreement, which kept it in place. Now, so the purchase agreement controls right up and through 11:59 p.m. on the 29th. But the sellers would have you believe that because of the termination notice and the rescission, that buyer had all the obligations, right, to wire the funds, but seller had none of the obligations. The purchase agreement is in effect, and if you look at section 8.2 of the purchase agreement, it lists clearly what the conditions to buyers, that's our obligations to pay are, and we've got evidence, and I won't belabor the record, in the record about all the things that seller did not do, right, that were closing conditions. Assignment of the membership interest. We've got, deposition.
Yeah, I mean, look, sure, except your client says, we're not closing, we don't care. So it's not like it's, there's an issue of fact there. I'm not going to, but it's not as if it was clear that you and your client intended to go.
And I can't believe I'm saying this after our last argument here a year ago. There's an issue of fact.
The phone calls weren't picked up, so you couldn't sort of move forward even if you wanted to.
Well, that's a whole other issue. Yeah, that we just didn't know that they thought,
Well,
right? We weren't privy to the fact that.
Once your principal says, we're not closing under any circumstances, then that becomes, but then there is more activity. So it's really.
It's a fluid situation.
It is, and I wanted to clear the air, though, on the Third Amendment and this idea, and I don't even need to get into the other part of that argument, which was that argument disregards this court's prior order. And that's all I have. Thank you very much for your time.
Thank you, counsel.
Your Honors, Judge Scarpula, you asked a question, and at the risk of getting in hot water,
I won't, as long as you don't tell me what I ruled on last time. As long as you don't just explain my last decision to me, you will not be in hot water, I promise.
I won't explain it, but I will ask you to take a look, if I could. You asked counsel whether the termination notice was withdrawn, and wasn't that a question of fact? The questions of fact, I believe if you go back and review the opinion that the court found the last time, was whether it was bad faith not to adjourn the closing date, and whether
Because the
date
actions of the
time of
parties after the 22nd indicated that they intended for the sale to go through. And a closing date was set for the 28th, which would be inconsistent with the termination on the 22nd. And then when the buyers asked for the, listen, I mean, we can go back and forth about this. I know the facts. I understand.
I can tell you know the facts, and I'd just ask you to look through another prism for 1 second. I do lots of corporate transactions. It is very common for a deal to be terminated, and then the parties that came close to talk further about trying to get something done. That's exactly what happened here. The contract was
That's a
terminated.
fact issue because there was a closing date set for the 28th. So I'm sorry, when you say the parties were negotiating, there was a closing date for the sale set.
For the buyer to prevail here, it is, I believe, there would have to be record evidence to prevail on summary judgment of a breach prior to the termination.
No one's saying summary judgment.
There is no such evidence.
Right, that's exactly right. You're going to trial because the party's conduct
The second
raises
point,
issues of fact.
moving on to
There are too many contemporaneous emails and text messages, which really doesn't lead to resolving this by summary judgment.
and the second point, which does absolutely mandate summary judgment, the Yatra agreement, in footnote 1 to Justice Borak's opinion, he stated that the two agreements are different in that specific performance did not survive in the Yatra agreement, while it does survive in the agreement at bar. I invite the court to look under section 8.2 of the Yatra agreement, general provisions. It lists the general provisions as surviving in Yatra. And section 9.9C is the specific performance provision.
Let me ask you this. What you are citing now, was that cited in the Yatra decision itself?
In which decision?
In Yatra. No, in Yatra. Let me look. I'll look. I have it here. I think those provisions that you're speaking of are not surprise provisions. They were
are, Your
discussed
Honor.
in the case.
They're not cited, I'm sure of it, because I wondered this point, and I said, maybe Yatra is a public company. So I went and found the agreement online, because it was not addressed in the court's decision. And lo and behold, the provisions are identical, and that is set forth in our brief. And I will buy you a coffee sometime if it's in there, because it's my recollection
Oh, you
that
got to
it
buy
is
the
not.
entire panel.
I can't write exactly.
So that is one important point. And the agreements are identical, and therefore Yatra is controlling authority. So even if you disagree with me about everything else, once the buyer terminated the agreement by its own letters on April 9 and 14, it elected its remedies, and it cannot sue for specific.
Okay, let me ask you one last question, then I promise that's it. Did you argue that the first time around? Yes. You argued that this, right? And it was rejected the first time around.
Rejected. It was not rejected. This court did not reject the Yatra point.
Did you argue that the first time around?
In the briefing, not
Yes.
the court. and the
Okay.
court
No, what
did
does
not-
that mean? You did argue it the first time around.
Yes, it was
And
briefed
it
to the
did
court.
not carry the day the first time around, correct?
Good reason. The court did not have a complete record, and it was fed a false argument. Now the record is complete. Justice Borak brought the same false argument. Look at his decision and look at the provisions in Yatra. It could not be more plain. It is provable in black and white. I know you want to get it right. Please look at footnote 1 of Justice Borak's decision. Then please compare the provisions that I just cited you to. Specific performance survived in Yatra just like it did here. That decision has been adopted by the Delaware Supreme Court, and this court is bound to follow it. No matter what it thinks of our client's conduct or the fact issues that went on, it is over. They elected their remedy. They are done. They cannot fight and flight. They cannot choose fight and flight at the same time. Delaware law is clear. Litigate or terminate. Fight or flight. You can't do both. Thank you for putting up with my retorts, and your promise of a hot bench was taken.
Thank you both. Wesco Insurance versus Mount Holly.
May it please the court, Timothy Delahunt for appellant. In any case disputing an exclusion, it's inevitably cited that exclusions are going to be narrowly construed. The other side of the analytical coin, however, is exclusions must be given a full meaning. It's conceivable that persons inside a building might refer to the first floor of the building as ground level. As I said in my brief, I think that's a stretch.
For the exclusion to mean what you wanted it to mean, didn't it need to say that you're standing on the ground? When you've used this phraseology of ground level, you've left open this ambiguity.
Well, workers get above the ground.
Thank you.
Workers get above ground level in a variety of ways. As the decision, notes, there could be a ladder, there could be a step stool, there could be scaffolds, lifts, et
It
cetera.
could be a paint bucket. And if it was, let's
It'd
say,
be a 2x4 with 1 inch above the floor.
let's say he falls off
Where
a
do
2x4.
Yeah, I mean, how do you possibly make a distinction? Judge Gorin started to talk about this. He talked about the step stool, but really, your definition just seems way off the mark.
Well, the decision, with all due respect, it suggests or it implies that it's inevitable that a contractor is going to be doing something in the air, feet off the ground. But it's not, because if you look at a contractor that's working on the interior, as Inside Squad was, they do all kinds of things. They move materials in and out, they move workers in and out, equipment in and out. They stage sometimes on the outside, they put dumpsters and bins on the outside. But this is different. This is now work in the air. And it wasn't on a 2x4. Those aren't the facts of the case. The case has to be decided
He's
on
fallen
its facts.
from 10 feet up on a ladder, but
Right.
the phraseology creates this ambiguity, even accepting the spin that you want to put on it. You leave open that ambiguity. Does it mean that, or does it mean that you've got to be standing on the ground? What you really are looking for this to be interpreted is that the worker is standing on the ground.
Well, the activities have to be on.
coverage, you're covered if the worker is standing on the ground. Anything else is excluded. But the phraseology you use to exclude it leaves open ambiguities.
I believe that's exactly how the exclusion has to be applied. And I believe the key here is more what I addressed on the reply, which is that workers working on the outside, working outside would not use the term ground level to refer to the first floor of the building over there, if there even is a building. When workers are working outside, they would use the term ground level to refer to what's beneath them. And what's the reasonableness here of Inside Squad when they procured this access policy? The accident occurred on a 12-foot ladder, which is plenty high. But also, they were working, admittedly, at heights up to 21 feet, and they were using scaffolds and scissor lifts. This was not the 2x4 type of project. This was not, cutting the onion that thin factually. That's not the record here. This was a different type of project. They did not procure coverage for that type of project. They could, they didn't, and Mount Holly didn't issue that policy. And so this, that's the legal analysis, and I would submit there's externalities as well here, because contractors are going to not provide the full scope of what they actually do, because they try to obtain better insurance terms. This leads to more disclaimers, it leads to more coverage litigation, it can lead to carriers leaving this market of the labor law. And so in totality, there's even given a narrow construction to exclusions. The result, this should be reversed.
But that would essentially mean that anytime someone was standing on the ground floor and was injured jumping, that the exclusion would apply, right? You're saying basically that your foot has to be on the floor. Okay?
I understand, Your Honor.
Right? So that, and I think that you've created an ambiguity, which we both agree, I don't think it's controversial. That ambiguity goes against you, not the insured. You could have said, except anything that has to be actually occurring on the ground floor rather than in the air on the ground floor, because there's no doubt this worker's ladder was on the ground floor, outside the building, inside the building, on the ground floor of a building that was being built. And the ambiguity goes against you, not for you. That's the problem.
Your Honor, I would say that the exclusion was very well drafted because it applies, remember, it just applies to exterior work. If it was all work above ground level, we might have a different case here. But the exclusion only applies to exterior work above ground level. And ground level is the best, most accurate term for describing the literal ground when you're outside.
So again, you're arguing that your foot has to be on the ground.
I'm not arguing that, Your Honor. I'm arguing.
Then what are you arguing? How does it, if you're out on the ground level, where do you draw the line?
It's the work. The work has to be not above ground level. So
So again, if I see a little piece of dirt on the wall and I jump up to get it, it's not on the ground level. You're saying that insurance doesn't cover it?
that's in that hypothetical. I'll add to it with your.
Let me interrupt you for 1 second and say, just the fact that you and I are going back and forth about this shows that there's an ambiguity that goes against you.
I would disagree. There has to be a back and forth when there's a dispute over an exclusion. And if Inside Squad were working outside the building and was performing with its work, a scope of work with its feet on the ground, no ladders, no scissor lifts, no scaffolds, and the worker did jump up to catch a smudge, the work in that situation was on the ground. Whether that guy was painting, putting pavers down, he jumped up. But Mount Holly could not say the work was not above ground level. This is different.
Oh, wait,
If
how
you
about
are-
if it's on a ladder painting?
That's
the
excluded.
First floor. You're saying that that's not ground level work?
If it's inside, it's not excluded. Once you move outside, ground level means the ground. And that's ladder work. That's not covered here.
But to accept, go ahead.
No, I was just going to say, you just outlined a number of things, ladders, scaffolding. Why didn't you just include that? Why didn't you just, wouldn't that have cleared all of this up if you had just included those common items?
Because the exclusion's not directed to types of ways to get above ground. The exclusion is directed to, you're not taking projects outside above ground level. So even if there was a laundry list, you can't use, it's an exclusion for a type of operation. It's
Why
not
didn't
directed.
you just word the exclusion, exterior work above the ground?
Same result. I think, Your Honor, because the ground can mean only the ground when you're outside.
But I think we're-
Ground level doesn't mean only the ground, but if you said above the ground,
I think you end up.
that's exactly right. It's the word level and how it's commonly understood to mean is what's creating the ambiguity, at least in my mind. And had you not used the word level and maybe said something along lines what my colleague said, we wouldn't have this back and forth.
Your Honor, I understand, and that's why I did in the brief, pay some attention to this idea of the notion of perfect drafting after the fact. These are underwriters that are are making clear, sufficiently clear what
But
they intend to
really,
cover.
if you meant to make clear what you're arguing for today, and I certainly don't mean to imply that your argument is in any way frivolous, you really had to have just said above the ground. Then this whole discussion wouldn't be possible.
Well, Your Honor, I believe, I understand the argument on its terms.
If that's the exclusion they mean, they ought to modify the policy.
Well, they can't modify the exclusion after the accident occurs.
For the
I'm
next
sure they would if they could.
The new ones that they sell.
Where I come back to, Your Honor, respectfully, is if you look at the actual record facts in totality, this was not those hypotheticals that I understand test the limits of the drafting. This was something beyond that, and I believe Mount Holly should be entitled to rely on both the wording of its exclusions and the facts in the record. Thank you.
Thank you, Counsel.
Good afternoon, Your Honors. Max Gershwire for the respondent. I won't belabor the point. I think Your Honor's questions reflect where we're coming from. And I would just add maybe that, as my friend and colleague, Mr. Delahunt, knows, this is not an unusual type of exclusion. That is, there are plenty, you see these kinds of exclusions in contractor policies all the time. What you see, what's different about the ones you typically see from this one is a very specific height. In other words, it'll say something to the effect of, no coverage for injury sustained for work performed at, say, 10 feet above ground level, or something to that effect. Because, yes, they could have, if the intent was to exclude coverage if the worker was any height above the ground, they could have done that. But no insurer does that. That is, when they draft exclusions like this, what they're concerned about are significant height.
And when you look at the pictures of the scene here, there's also like a staircase in the area. The plaintiff didn't fall from the staircase; he fell from outside the staircase, right?
That's right.
And, how would you regard those stairs, which are coming off of the ground level into the building? Where do they fit into this?
I think, again, given the way that Mount Holly chose to draft this exclusion, as long as it is on the face of the ground floor of the particular building that the work is being performed on, it is outside the exclusion.
What about your adversary's point that ground level, really what you're talking about is the first floor interior, and this is something different, is exterior work, and we're talking about work being performed essentially above the ground?
Yeah, I don't understand that distinction, quite frankly, Your Honor. If you're working, whether you're working inside of a building or on the surface of the exterior of the building, there's still, you could be working on the second floor, you could be working on the ground floor. I don't see how the terminology changes just because you happen to be working on the outside.
He places a lot of importance on the absence of the article "the," so it doesn't say the ground floor. Would you respond to that?
Sure, Judge. I get the argument, and I would say that probably typically the article is used when referring to that, but I don't see how that makes it more likely to mean the ground itself rather than the first floor. And again, it leads to the absurd result, which Justice Ngor pointed out, that if you take that to mean just the ground, it leads to absurd results that could not have been within the reasonable expectations of the insured, where you have, if you're on a step stool or a 2x4 or anything like that, you're suddenly outside of coverage. Thanks, Judge.
Thank you, Counsel.
I would only add, counsel referred to the type of exclusion where there's an express designation of the cutoff, 10 feet, 2 stories, 3 stories. Those cases are out there. Those exclusions are out there. But that would be the type of exclusion you would expect if the carrier was willing to cover some exterior work. The difference here is Mount Holly was not willing to cover any exterior work other than feet on the ground. Thank you.
Thank you both. Brody? Whenever you're ready, Counsel.
May it please the court. My name is Len Fiwis, and I am, excuse me, I'm counsel for the plaintiff appellants in this case. I'm sure the justices have read the briefs, and so they must recognize that this case reflects a dispute that is quite familiar in New York. It's part of the familiar and recurring pattern of many New York condominium boards, which often abuse their powers in order to utilize contracts of adhesion, utilize fines and fees that are put into bylaws and
Why don't you get to the specifics of your arguments? We're
Sure.
familiar with the contours.
Sure. So there are really two issues for the court to rule upon. The first is whether or not the Supreme Court erred when it determined sua sponte, really, in the order that the Brodies did not timely complete the construction work.
You say that the court substituted his judgment for Mr. Campagna's, the architect, but really, wasn't he just enforcing the alteration agreement, which says that the determination is conclusive if it's by the board?
Well, Your Honor, with respect to that specific point, it's well settled law under New York law, that if you have a contract that gives conclusive determination to one side or the other, then that conclusive determination is not absolute, but it must be exercised reasonably and in good faith. And here, there is no evidence whatsoever as to how the board exercised its judgment at all. It seems completely arbitrary.
What about the whole letter writing after the order to show cause procedure maybe muddied the waters, but there are those photos that were submitted pursuant to the letter. They're unsworn, they're unauthenticated, but no one said they didn't show what the apartment looked like. And they were photos taken by the super. You know the photos I'm talking about. They're in the supplemental record. And they do seem to show, bare sheetrock and an unfinished apartment.
Right. So there are a couple of issues with that. First of all, the photos are unaccompanied by any affidavit or testimony. We don't know who took them, under what circumstances, and whatnot. Number two, because...
Did you challenge it at those grounds below?
Well, I didn't have an opportunity to challenge them below because there was no motion practice on this. There was simply letter writing.
But you got a copy of, you sent in, both sides sent in letters, right?
Yes.
And you got a copy of that letter.
Yes.
And you sent in photos too, right?
We sent in letters.
But didn't you initiated motion practice by letter, in fact, isn't it?
No, I did not, Your Honor. The letter application was made by the defendants after there was a motion for sanctions.
Okay, so fair enough. I got that wrong. But in your letter, did you tell the judge, Judge, please don't consider this. This is inappropriate. Make a motion on notice, et cetera, et cetera. Or did you continue that process?
We did not say that point blank, but we did not expect the court to simply rule on a letter application concerning a critical contract issue in the case based on a one-line letter, a two-paragraph letter by counsel with no affidavits, with no support, with just 4 pictures. And after, what we did was we wanted the court to see that the assertion that was made, the naked assertion that was made that the work hadn't been completed, was contradicted by actually an architect's certification that we had provided. The architect's certification is clear on its face, plain on its face. It says the work as it's defined in the alteration agreement, which constitutes the things that we submitted the plans for. There are architects that represent, architects and engineers that represent the board. The architect for my clients had been long in contact with the
Yet, even you refer to the certification, but yet even the alteration agreement 5E says, with respect to the certification, it's the board's determination that shall be conclusive.
Yes,
So again, I mean, that was the premise of the decision below. Why isn't that accurate?
Well, I'm not saying that the board can't ultimately make a determination. But on this record, the board did not make a determination. All they did was have an attorney submit a letter with 4 pictures that were unsubstantiated. There was no proper record, no evidence, no testimony, simply saying the work isn't finished. Now, I can give you 8 million explanations for why those photos don't show that the work isn't finished. And in fact, the architect gave not only 1 certification, but 2, a second one after the court's ruling, explaining exactly why the court was wrong in its determination.
Those letters are also unsworn. This is another problem we have here, right? I mean, Mr. Campagna's letters, they don't say
Absolutely.
where to the truth is.
And I think the appropriate
Yeah,
relief.
but the problem is you didn't do anything about it. You didn't say to the court below, once the court made that ruling, and then you sort of made a motion to renew, right?
Yes, because we,
Right, so then so at that point, did you say to the judge, you should not have done this on motions, on letters?
I believe, first of all, there was.
Let's start with, did you say that to the judge?
I do believe at oral argument, I made that point, and
I'm saying, did you in a motion or anywhere on the docket that I could see, anyone who looked at the docket, did you object to that procedure?
Well, first of all, with respect to
Pretty straightforward. Let me just
the answer
yes?
to that is no, but
Okay,
but
that's
there
all.
was no
Let's start.
expectation by me that the judge was going to decide the issue based on a letter application.
Okay, so stop. After that happened, right?
Right.
Did you ask the judge to vacate the order?
We did not make a motion to vacate. We made a motion to renew.
Okay, either way.
Okay,
right?
and the
did you
motion-
so at some point you did have an opportunity to put in whatever else you wanted and everything else that you should have.
Well, look, the bottom line is that an issue like this, a critical issue concerning the meaning of work under the contract, meaning what is conclusive determination by the board under the contract, these terms are critical to the case. They should be decided on summary judgment, not on a letter application that's submitted by the other side, and the judge makes a knee-jerk decision without even telling us, includes it in a motion that has nothing, that was fully briefed already, fully argued. He decides to just consolidate the letter application with the motion that's pending but fully briefed. I had no idea he was going to do that.
No, I know, but the problem is that you didn't do anything about it below to correct it.
Well, I
So
believe
it's very difficult on appeal to fix something that you didn't
understood. But when we moved to renew, I believe the basis of our argument was that it shouldn't be done. It should not be done without looking at parole evidence and taking testimony. And we submitted parole evidence. We submitted bylaws, and he refused to even consider it. He said there was nothing that I misapprehended. There was nothing that I misconstrued. And so, look, you can, if you want to deal with it in terms of the fact that he didn't have a proper record before him, he didn't follow proper procedure, all you have to do is vacate without prejudice, send it back down, let this be the subject of proper motion practice, and then we can fully adjudicate it, and it will be resolved, and one party can appeal or not if they so choose. But on this record, I think it's inappropriate for the judge to have decided critical issues, but more importantly, substantively, the judge got it wrong, because the judge should not be looking at an architect's certification and entering his own personal judgment as to what it means. The judge should not be looking at the contract.
Wait, let me just say, is there any dispute that the board said the work wasn't done?
Look, I don't dispute. I do not dispute.
Okay, so the board said the work wasn't done. It's not the judge saying that, the board said it, right?
But they did not say what work wasn't done. All they said was the work's not complete. And by the way, for the last year and a half, we've been asking the board to tell us what work isn't complete. In fact, they had an inspection in January, just the end of January. They went in, they came out, and we said, is the work complete? They said no. We said, what's not complete about it? The people are living in the building where you have a C of O. And they won't tell us because they are now resting on this decision in the belief that because the judge ruled that they have the conclusive determination as to whether or not the work is complete or not, and they can fine us if they determine the work is not complete until the end of time, they're simply going to sit on their hands and say, the work's not complete. And that's the interim effect that naturally flows from the court's wrongful decision. What's critically important here is that I don't doubt that the agreement says that they have the conclusive determination, but that doesn't give them an absolute irrebuttable
Well, so then your remedy in that instance is to say that they're acting in bad faith. That's exactly what you should be doing. If they come out and they won't tell you what's wrong, then you bring a motion to for them acting in bad faith.
Well, what we said.
You're a shareholder, right?
Yes, Your Honor.
Yeah, so you bring a motion that the board is acting in bad
Look,
faith.
we certainly will do
People
that.
do that all the time.
But listen, the relief, the relief that we're asking for is very, very narrow and focused. All I'm asking is for the court to vacate that small portion, the 2 pages of the order that were based on a letter application, there was no proper record, there was no proper procedure, where the court reached out and determined what a contract term meant, and you can review that de novo and determine whether or not he's right or wrong. He said that what is work is defined by a functionality test. There's no evidence anywhere in the record that functionality
Even if we agree with you, though, the alteration agreement defines work as anything included in the plans, right? So
sure.
So that's what we can.
And the architect said these were not things that were in the plan. He said they were decorative items, and the court contradicted that without any evidence submitted by the board to support that. He made that determination.
Well, the
There's
board
nothing-
made the determination,
No, the
right?
board
Did
did
not the
not.
board
The
say?
board did not address that. The board simply said work isn't finished.
You're saying the board didn't say it's this kind of work, this structural or whatever.
Absolutely, they did not.
Non-decorative work because there's something in the alteration
Yes,
agreement
in-
and in the
in
bylaws
fact,
that allow you to do
In
decorative.
fact, to circle back to the pictures, what happened in actuality was they sent the super up to the apartment without telling us. The contractor was up there covering up tiles, covering up the floors, covering up the tiles, putting, in different places because in advance of the painting team coming in, they didn't want to ruin the floors, they didn't want to ruin the tiles. And so the 4 pictures that were selected and shown to you were picked specifically to show the worst looking apartment possible, but clearly had nothing, do not reflect an apartment that's not structurally finished or is not finished pursuant to plans. It's an apartment that's getting ready for somebody to move in, for somebody to do painting, for somebody to finish decorative work, and that is what the architect said twice. And the court...
Counsel, I'm going to stop you. You've gone over the red light a lot, but let's
Thank
hear
you.
from your adversary, and then we'll get back to you.
Good afternoon, Your Honors. Barry Margolis for the respondents. I think it was a little dizzying listening to counsel. I think the court
Primary argument, as I hear it, is that this is an unorthodox procedure, and essentially the shareholders have been prejudiced as a result of decision-making not by motion, but by letter writing.
Yeah, there clearly was no prejudice. I mean, in fact, in New York County, many judges, whether commercial division or non-commercial judges, entertain applications by letter, make rulings based on letter, and there's a process. And in this particular case, Judge Knock entertained our letter, which is contained within the supplemental record.
Counsel, how do you respond to the accusation that you haven't still to this day told the shareholders why the plan isn't complete?
Well, first of all, that's just a factual statement that's not true. Okay. And it's not in the record before this court because obviously what we were talking about and what counsel is raising now is something that took place 4 weeks ago in 2024. There was an inspection done, and as far as we know, the work is completed. What we're talking about here is this.
I'm sorry, are you saying the work is completed now, even though this is outside the record, but is it completed now?
From what we understand, yes, the work is completed.
We just want to know if your case is coming back.
Oh, yeah. Well, let's hope not, because we saw videos the other day, actually, at one of the depositions showing a beautifully completed apartment finally. The issue is that this project...
Your point is that the work wasn't completed in December of 2022.
The work was not completed per the judge's order on 11/30/2022, which was the deadline that Judge Knox set. The next day, we had an inspection. We were permitted in the apartment because the judge had set a date for completion. We went in.
And you take pictures at that
And
point,
we took
right?
pictures at
How
that
did those
time.
pictures get before the court?
Those pictures got before the court because I wrote a letter to the court, which is in the supplemental record, which the plaintiffs did not put into the record, but I initiated the application to the court. It's not 2 paragraphs, it's a page and a half describing for the court what the board, under the alteration agreement, conclusively determined, which was incomplete work.
Counsel, is that competent evidence, though? I mean, I'm sure you wrote what you thought it was correct, but that's not competent evidence.
It was competent for the purpose of bringing the issue to the court's attention, which we did. Counsel then responded to it and did not object to any type of process before Judge Knock. We then responded. I believe they then responded. Then they made an application for contempt. At that point in time, they did not.
No, they'd already made, I think they did the order show cause for contempt prior to the letter writing, didn't they? They did, yeah.
The timing, you're right, may be correct, Your Honor, but the point I'm trying to make is they had subsequent opportunities, including in their motion for re-argument, which was not, by the way, a motion for renewal. It was a motion for re-argument, which was denied and is not, as a threshold matter, appealable as of right.
I mean, I think opposing counsel says, look, there's nothing which shows that the board considered this situation and said it's not complete. What establishes that the board looked at the premises or looked at pictures of the premises and made a determination this work isn't completed? And I will grant you, when you look at those pictures, it shows unfinished sheetrock and an unfinished job. And undoubtedly, there'd be a need to do plenty of knocking to finish that off. But where did
Judge, I'm an agent. I'm an agent of the board. The board is my client.
No. When it says the board has, you cannot vote for the board. So what I'm at, let me just finish for a second.
Of course, Your Honor.
Again, what I'm asking, what the judge, is being asked, where's the board resolution? Where's the board vote that says that this isn't done? I mean, counsel is arguing to us, the board never made that determination. Judge Knock did, and clearly he's not the one to make that determination. It had to have been the board. So where is the evidence that the board considered and made a determination?
The board made its determination.
How? Where?
The
Where
board
in
made
our
its
record?
determination when its resident manager inspected the premises on December 1st, took pictures which conclusively established it was not complete.
Are there minutes that reflect that there was a meeting, that the super came up? I was on a board once upon a time.
It's not required, Your Honor.
But the provision does say, it says determination. So determination doesn't that mean that the board will meet and determine?
Not at all, Your Honor. It means that under the alteration agreement, it's the determination of the board, meaning its evaluation of the circumstances giving rise to the...
I accept that. But where is that determination? Because the language in 5D is, quote, the determination of whether the work is completed shall be made by the board, and such determination shall be conclusive. So it's the first part. Where is that determination?
There is nothing in the alteration agreement or in any law that requires there to be a formal practice here. What happened here...
Well, okay, that's fair. Where's the affidavit from the president of the board that says we met and we determined that this wasn't done? Where is a board minute? Where is a board meeting? What have you put in to show that, just list for me without argument, what you put in to show that the board made that determination?
Well, what we put in was, as set forth in the supplemental record, which was my letter, no affidavit.
You're not on the board.
I am not on the board,
Okay,
Your Honor.
what
but
else?
I was tasked, I was directed with authority to speak. I'm an attorney on behalf of a client who had the authority to communicate to Judge Knock what the board observed. I submitted my statements alone were supported by photographs that were taken by the resident manager. Plaintiffs then engaged in a process. Ultimately, Judge Knock made a decision based on the letter writing, which was never opposed. There has been never an argument that that process was inappropriate, ultra-virus, not consistent with the law until this appellate process. Had the judge in that decision, which he did in the contempt motion decision, he could have made a motion to vacate the judge's decision. He did not, and therefore that decision stands. It's not appealable as of right, as a threshold matter. And so, there is a practice, as I'm sure those of
So
you...
can I interrupt you for a second and just say, I want to make it clear, the only thing that you're saying would evidence that the board considered and decided under its authority, under the agreement, is your letter. That's it. There's
my
nothing.
letter with the building's photos, not my photos.
Right. That's it. There's nothing other,
Correct.
right.
I marshaled those photographs of the building.
Again, I just want to make sure, that's the only evidence we have. That was the only evidence in front of Judge Knock, was your letter, your unsworn letter, and pictures, and unsworn pictures, right? Unauthenticated pictures. You didn't take those pictures, did you?
I did not take those
You
pictures.
you didn't authenticate them? You didn't swear to anything in the letter, correct?
The answer is correct, but in the informal process that Judge Knock entertained here, he didn't require us to do anything more than that. And frankly, what counsel did in response, as you know, is they submitted the certification of Mr. Campagna. Mr. Campagna's letter wasn't submitted with an affirmation or an affidavit. And by the way, Judge Knock distinguished what that purpose of that certification and how it's
Appellants point to that provision, subdivision E, as if Mr. Campagna's letter means that they finished the work, which of course your comeback to that is that no, that's only that it complied with the code. But I suppose there is some support for what you're arguing about the letter, in that it's just turned over to the agreement turns it over in subdivision E just to a letter from Campagna.
correct. There's two different operative provisions, one in D, which speaks to completion and a determination of the board. And there's a second piece where you need the architect to certify compliance
from
with
the
the
architect.
code.
Subdivision E it requires a certificate from the architect.
To certify that things were done in accordance with all applicable laws and codes.
In the code.
It supplements.
The agreement doesn't turn over to Campagna the authority to decide whether or not the work is complete.
Not at all. There is no abdication of the board's authority, which is commonplace, whether it be a co-op or a condo in New York.
Counsel,
The board is the ultimate authority.
can we just switch for a second? And can you talk about the fines that your client imposed for the period before, when Judge Knock had extended the time period when the work had to be completed? For that period?
There were no fines in the period when the judge preliminarily nullified the stop work order. And that was the only order of the court to make very clear that to the extent there were any fines during a period where the court had issued an
Counsel,
injunction.
I'm sorry to interrupt you, but following up on Justice O'Neill-Levy's question, why would the fines for February 2022 to July 2022 be any more valid than the fines that were disallowed by Justice Knox's order? In other words, shouldn't they be obviated, shouldn't they be expunged as well?
Well, what he disallowed were fines during a period of time where he entered in an injunction.
Right.
So that's what distinguishes the
But given that he
fines.
set the termination, or he set the completion date as of November 30th, shouldn't all fines prior to November 30th be expunged?
No, because as we argue in our papers, the fines that were issued starting from when the board determined the work should be stopped pursuant to the stop work order, that
How can you have a stop work order when you don't even have a completion date?
because as we set forth in our papers in support of the application for injunction and was before the court, there was a schedule that accompanied the alteration agreement, which specifically identified the time frame from when this work was supposed to have started and ended.
Yeah, but if there shouldn't be fines from June to November, then there shouldn't be fines from February to June.
No, June to November, the judge enjoined that period because he had
Right,
elongated.
because they still had a right to do work. He decided they can still be doing work. So if they had a right to be doing work in June, they had a right to be doing work in February.
Evidently, Judge Knock concluded that they had a likelihood of success on the merits. But inasmuch as that was an application for injunctive relief, effectively what this court is saying, but through those questions that you're asking me, is that the court should have made an ultimate determination on the ultimate relief of whether or not we were or were not entitled to fine them for that period on an injunction application, which is what Judge Knock decided on June 24th. That was not a determination on the merits. That was merely a limited scope determination as to whether or not the stop work order should be preliminarily nullified. There's nothing in his order that says that any fines at any period of time as of that point or even to follow should have not been imposed.
Are you contesting at this point that they should have been allowed to do work until November 30th? Is that still a live issue in the case?
No. In fact, the judge ruled they could,
So
and
then
we
there
allowed them, and there were no fines between that period of time.
So then prior to November 30th, there shouldn't be fines.
There were fines because there has not been a determination on the merits as to the circumstances that existed between February and June. The judge made a decision to allow them to continue work. There is no doubt about it. But that is different than a determination on the merits as to whether or not, under the alteration agreement, we had a right to delay the work and whether we had a right to fine them because the project had then been going on for nearly 3 years and had not reached conclusion. The agreement, the alteration agreement, has very specific provisions in it that allow for the surcharging.
Counsel, did COVID have anything to do with the fines in the period we're talking about just now? Could work, for example, be even undertaken at certain periods?
COVID had a very, very limited role here, Your Honor. COVID, there was a short pause that Governor Cuomo had put in effect.
And then that was fair enough. But after that, were workers available? Were supplies available? We were going through a rough time in this world.
There is no dispute here that there were certainly factors that impacted this job. However, the record is very clear, and again, this is, I think, outside the scope of the issues on appeal, but the record is very clear that the work that was being performed in that apartment, which should have started in 19, was not progressing even before COVID in a timeline that was consistent with what the parties agreed to with the condominium. The project went on and on and on. We have evidence that things were installed, then ripped out because they didn't like it, then they installed it again. It's true that apparently they had workers coming from Italy and abroad, and that might have been impacted by COVID thereafter. But what we had was a lack of diligence on the part of these unit owners, and the board merely stepped in and said, after being very gracious for years, and said, listen, we're now on year 3. When are you going to bring this to a halt? And still, even after Judge Knock ruled that on December 1st, the work was not completed, and that's 2022 now, right? It's still going on into 2020, late 2023, 2024.
Counsel, I need to stop you here. Thank you.
Thank you,
We're
Your
going to
Honors.
be going on and on, too, like the work.
Just to clarify some of the questions that you asked me. First of all, with respect to the letter application, there's one letter that set this off. It's at Supplemental Record 2 and 3, Mr. Margolis's December 6th letter where he sends in the 4 pictures. That letter does not make clear that he's asking for an order, he's asking for determination on work, anything having to do with the contract. He's raising to the court that he believes that my client is still working, and he's asking for the court, he literally says, plaintiffs are continuing to perform work within their apartment despite the reinstatement of stop work notice, and he says, defendants seek the court's intervention to address plaintiff's clear violation of the June order and the untenable position that plaintiff's work continues endlessly, which is consistent with the misguided position that the
Again, counsel, but in response to that, right, was your response to that was not, this is inappropriate, make a motion. That wasn't your response.
Well, true, but
then when you
our,
got
our
an
immediate
order-
response was that it's not true factually. But my point is, we had no reason to think that this was going to be taken up on motion practice. We believe this was a request for the judge to conference on this.
No, but even when
And
you
he
got the
actually
order,
asked-
but when you got the order, you didn't move to vacate.
Yes, but we did.
You moved to re-argue.
Move to re-argue, and in that motion for re-argue, it's at page 243 of our brief. In that motion, we specifically said that the court erred in making the findings on the record before it, and we asked told the court that it shouldn't have done so. So it's form over substance to say that we didn't vacate.
Counsel, in the letter writing campaign, is there an explicit statement that there was a determination by the board that the work was not completed?
No, there is not. And not only that, in the entire case, there was discovery so far in the case. We took the deposition of the president of the board. No board minutes have ever been given. There's been no testimony that of any determination that the board made on
Wait,
anything.
okay, so you took the board president's,
Deposition.
what did he say about how the board determined that?
I don't recall and didn't produce any minutes. And I'm sure there are.
Well, you didn't recall a meeting at which
Did not
this
recall.
was discussed?
Did not recall the determination, and simply.
And there are no board
and
minutes
there are
and
no
nothing?
board minutes produced, even though we requested them at the
How many
beginning.
members are there on the board?
I believe 6.
And how often, yeah, we'll have to. okay.
She told me the board meets monthly, and she said that the minutes are maintained by Allied, which is a
And
defendant.
your way of claiming that the work was complete was by sending in this letter from Campagna.
Exactly, and we had no idea that that his decision. I mean, the letter from Mr. Margolis says we look forward to hearing from the court. Our expectation that we were going to conference on this and perhaps decide how to proceed, but we wanted the court to immediately see it's not true. We do have a certification from an architect, and then before we know it, this decision comes down, and he tucks in this.
There's no provision in that agreement providing for Campagna to sign to decide whether the work is complete or not.
No, there is specifically a requirement that
At the code.
that we must provide it,
compliance.
that we must provide his certification that the work
Code
is
compliance, but not for completion of work.
no for the completion of work. It's
both, right? It's
with respect to all work that is subject.
That's
to the
not
plan.
binding on the board, as we've discussed already.
No, it isn't binding
No,
on the
that
board.
letter is supposed to indicate that he says you've complied with the code. It doesn't say that you've completed the work. That provision is very specifically limited to code compliance.
I can show Your Honor the language in the alteration
I'll-
agreement
I'll have it in
specifically.
front of
It's
me.
5E. It says 5E, evidence of completion. Upon completion of the work, the unit owner shall obtain and deliver to the sponsor and the board, 1, a certificate from the architect or engineer who prepared the plans certifying that the work as defined has been completed in accordance with all applicable laws and codes and the plans and all required final government sign-offs and approvals.
As that the work has been completed in accordance with all applicable laws and codes and plans.
Plans is a defined term, which is the plans that we submitted to them as to what the scope of the work would be. Now, I do not dispute that in light of an architect's certification, the board could do an inspection, come back and say, look, we disagree with Campagna. This, and this aren't complete. And then we can respond to it. We can cure it.
Board would include the resident manager, right?
What?
The board doesn't itself actually have to go through the apartment. They could have their resident manager.
Absolutely, but the board should deliberate. The board should provide us with a writing or information, whether it's through counsel or not, as to what isn't complete about it. 4 pictures with no affidavit, no facts whatsoever is not a substantive good faith response. It's arbitrary. And all we're asking is limited relief. Simply vacate
Last
without...
thought, counsel, last thought.
Just vacate without prejudice that determination. And I note one more thing. In Judge Knox's own decision on this issue, page 11 and 12 of his order on the sanctions motion where he addresses this, when he talks about the conclusive nature for the board, he immediately segues into the following sentence. That's not the stronger of the evidence. The stronger of the evidence is the architect's certification. And then he goes through his own interpretation of what the architect's certification says and why it's insufficient. So he himself recognized that the simple one-line sentence and 4 pictures that were submitted isn't the stronger of the evidence. The stronger of the evidence was his own determination that he shouldn't have been making. And so that's also something that I think you ought to note. And again, we're just asking, vacate that portion, let it go back down, and let there be a proper finding on a fulsome record that, summary judgment or whatnot. Letter applications.
Thank you, counsel.
Thank you.
Thank you.
Thank you.
Thank you both.
Cleared the room.
Harry, that's the first time anybody's told me that the work is complete.